Good afternoon and welcome to the June 10th work session of the Arlington County Board, our police practices group, and our stakeholders regarding the Police Civilian Review Board. First, wanted to just provide a little context. The police practices group, of which we have a subcommittee, did extensive work, produced a 90-page report over the last year, and we are grateful for all that work. Arlington County has taken a series of steps over the last year to respond to some of the need for 21st century police practices and building trust with our community as a whole in light of last summer's murder of George Floyd and also the ongoing work for racial equity and fair criminal justice that we have seen a need for. And so we started that work, and it's translated specifically on this issue to the Civilian Review Board, which was part of that 90-page report I mentioned. And we're grateful that our police practices group, I believe our Commonwealth Attorney and our public defender are or have joined us. And so we have an agenda that's meant to help us understand how this would work in practice. And we'll send it over to the manager, who's got an initial report. Then we'll want to hear from our police practice group subcommittee. This process is part of what started at our May board meetings, where we advertised for an ordinance to adopt the Civilian Review Board. So with that context, it's over to the manager for discussion and his presentation.
Thank you, Mr. Chair. I did want to start off with an apology to Rodney, Kent, Saul, Kim, and Latasha, because I have my notes from the phone call I made to all of them last July saying, we'd only need you for a few months. We'd definitely be done by December. So see, there you go. Thank you very much, Mr. Chair, and everyone here. I'm going to spend, I've not tried to spend a lot of time talking, because we actually have with us today the people who spent a lot of time looking at the issue. And then Captain Chamberlain, one of the reasons why she served on this subcommittee is that I think she can speak specifically to one of the documents that's been posted, which is Arlington County Police Department's internal procedures when it comes to Office of Professional Responsibility investigations. I think that's important. Another document that was posted on our website was the Virginia Acts of Assembly from the 2020 session, Chapter 29. That's the full authority that is provided to the county board in considering what kind of a civilian review board to put together. And then the third document, which I think that, I think at some point we probably want to post as we go through this, which is we tried, staff did, along with assistance from the board, to try to focus on 3 different kinds of fact patterns and see how the various proposals that are out there might handle them, to try to come to some understanding about what the decision points are. So very broadly speaking, the 3 sets of scenarios are as follows. The first large, I think the one that's likely to be the place where a civilian review board spends most of its time, I'll put into the category of there's a complaint or an allegation that some action taken by the police was biased or discrimination, and not really criminal conduct, but it could be related to a traffic stop. It could be related to an incident where a police officer is called to a scene because of a call to our 911 center, and those kinds of things, which can be sort of, I don't want to call them run of the mill, but they can be fairly much more common than what you might find in the other 2 scenarios. One would be the other scenario, one of the other 2 scenarios would be your, out and out use of lethal force by the police department that is, in my mind, more likely to result in some sort of criminal investigation. That sets up a whole set of circumstances. And then sort of the other bucket is something that might result in civil litigation, where there's an action taken by the police department. I'd analogize it maybe to something where our civil disturbance unit is in action and takes some sort of action and could be subjected to a complaint from a resident. So I know that's just very broadly speaking over those 3 buckets. So if it's okay with you, Mr. Chair, I'm going to try. I know Teams has switched up the way you share documents, and I haven't done it for a little while. I'm going to try to put up the side-by-side analysis of that first bucket, if that's okay with you. Does that make sense?
Sounds good. Thank you.
Okay, well, wish me luck. Here we go. Okay. Tell me if you can see it.
We can. It's a little small. If you're able to expand, or I don't know how that best would work, at least on my screen. That works, and maybe scroll down and we'd see the whole thing, or the whole first page.
Okay. So I think what would be most productive, and we've given an example there of the Foxcroft Heights complaint, because that's something that's more of common knowledge. And I think I'm going to turn it back to you, Mr. DeFerrandi, and then to ask everybody who's here today to see whether we've accurately described, and remember what I said, there's like so many possibilities, but accurately described the kinds of things in sort of the fact pattern that would take place on either of those two scenarios. One is where there's a call into 911, or one where there isn't a call into 911, and there's a situation where an incident becomes publicly known, or there's a complaint filed of some kind. So, I mean, I think that's what we've tried to put there at that fact pattern. You can see under my proposal, I had suggested that the Office of Professional Responsibility would conduct an investigation, and then following that, the Civilian Review Board would have access to all that information and do its own investigation. And then we have the other alternatives there. So not looking to play ping pong with you, Matt, but I think I'd send it back to you so you can figure out how you want to walk through that.
Sure. So I think, the agenda had, I think we should try to walk through each of the scenarios. And one question that will come up, we'll start with a complaint originated with a 911 call, and then talk a little bit more about the other scenario. And I think just to sort of prep Mr. Turner and the police practices group subcommittee, why don't we kind of look through the county manager's proposal and then the alternative. There's also Alexandria, but we would be interested. I'll sort of start to walk through those first three and then see if the police practice group would have comments. One issue that I think we will want, just for everyone's understanding, we have through until July 17th, and we thought it important to start these scenarios in this conversation now so that we develop a deeper shared understanding of what we're seeking to do. So one point for perhaps follow-up research that we might want to do is the Office of Professional Responsibility, whether there are statutory code timelines that would be involved in this scenario of a 911 call. And I don't know if that, this is where Captain Chamberlain, this is, being on, you're wearing a couple of different hats, or Mr. Schwartz, if either of you know if there are relevant timelines, because that's what's mentioned in the county manager proposal.
I think Captain Chamberlain can speak to what the timelines are in the police department's directive on this. I do not have knowledge about whether there's any statutory requirement on this. I'm not aware of it, but Latasha, why don't you start out with that?
Okay, so right now, currently our practice is 30 days. Due to the amount of video that we're needing to review, we were making a consideration to move that to 45 days. But there are no statutory requirements for it.
So it's one of the many policies that is adopted, probably like an administrative policy, but written in that policy form, which the department uses. Is that fair?
Correct. Great.
Okay. So I'll go ahead and move to the advertised alternative to try and suss out a little bit of my thinking about this. And I'm open, colleagues, feel free to jump in. But if you look at the advertised alternative, the Civilian Review Board would have its own authority to conduct its investigation, and if if the alleged action falls under the definition of severe conduct. So for me, the thought of two immediate investigations doesn't most concern me. It's the instance where there is a lengthy process that leads to that investigation that is some of my concern. So that's just seeking to elicit and perhaps prompt police practice group and Commonwealth's attorney and public defender as you have thoughts. But I will show steady transparency and indicate that Vice Chair Crystal also was pretty deeply involved, meaning most all involved in drafting this. So I'm going to see if you have thoughts as we walk through this. I want to prompt discussion, but I know that we'll have lots of thoughts. So go ahead, Vice Chair Crystal.
Thank you so much, Chairman DeFranti. Thank you so much, too, to the PPG, the Commonwealth's Attorney, the Public Defender, for being with us today. This, to me, is the real meat of the question, not if investigatory authority, but what kind and how. And so I'm really excited to have the chance to probe on this. I was just going to frame maybe the question to kind of ask you all directly for me, as I pulled this together, is how are these investigations sequenced? Certainly, the managers clearly articulated a vision in which, it's OPR does its work completely, and then the CRB reviews. We have a county board alternative advertised. In Alexandria, it looks like the CRB maintains jurisdiction and decides whether to assign a complaint to their equivalent of the Office of Professional Responsibility or to maintain it for themselves. And so I'm really interested, to sort of tee this up explicitly as a question to get thoughts either from the PPG subcommittee about what you all envisioned, or any recommendations from our county attorney or our public defender about how do you sequence that correctly? Is it not a concern to have overlapping investigations? If it is, what are your thoughts about who goes first and what that handoff looks like? So to the extent it's helpful to just sort of tee up the big question on my mind anyway, that's what it is.
I think maybe the opportunity has to go first to Mr. Turner, but also to the others of the subcommittee.
Thank you, Mr. Chairman. To be blunt, on a lot of the recommendations, we didn't go into a lot of the granular details with regard to issues like sequencing and investigations. And so the question becomes, what can be done, what should be done? Me and the chairman spoke last month when we were setting up this call, and I speculated to him that I said I thought my recollection is that when you had the separate investigative bodies, that certain types of conduct were sort of separated out as to who would investigate what. Subsequently, I've done my further research, went back and looked at some of the stuff I looked at previously, and I found out that's not quite accurate. And so the question is a fair one: how do you sequence them? Because the CRBs or oversight bodies have broad jurisdiction over conduct that you would assume the police department would investigate as well. I did a spin through of several of the operating procedures for other organizations that have investigative authority, and none of them give you any insight on it, unfortunately. I looked at Atlanta, I looked at Denver, I looked at Oakland, and some others, Chicago as well, I believe. And so in as much as there being a definitive answer, I don't have one. What my thought is, my perspective on this is, and this is not, it's going to frustrate you further. It's going to be, what can the budget handle for this body to do? Because if you're going to have a robust investigative function, you're going to need a robust body of investigators to do that function. We have no sense of what the volume of investigations will be in our jurisdiction. And typically with civilian oversight, the investigation is triggered by a complaint that comes into that body. And as I said before, a number of them have such broad jurisdiction over the conduct, it would cover just about anything that involves police interactions. And that's going to be, that's a question of how we want to implement it here, obviously. And we didn't suss that detail out either. So to bring this conclusion, it's still an open decision, open perspective from my open question from my perspective. It's going to be a question of what we think the public wants, because what's the purpose of this body? Is it to help bring transparency and accountability to the process? And if that is the case, will the public be satisfied with saying, okay, we're going to sequence this and CRB will always go second? Because that looks more tantamount to review authority as opposed to investigative authority. So those are my thoughts. Saul?
Thank you, Mr. Turner. Saul, and you may not have known that your chair of your subcommittee was going to immediately call you next, but that's all right.
It's okay. I'm used to it. I would have to say that I do agree with what Rodney just said. We did not go into detail, and doing research, you really can't really find any guidance on this. But one thing I do agree with is that the public's opinion is very important, and so taking this to the public and listening and hearing what they have to say and their recommendations on what they want the CRB to be, or whether it's a CRB or oversight board, is what's important here, so that the public would take their input into this and then decide from there, what sequence or how you want to pursue complaints. As Rodney mentioned, one of the intentions that would trigger an investigation by the CRB would be a complaint coming to them. So I think it would be important to hear from the public on how to approach different scenarios.
That's very helpful and leads us towards, we will be having a listening session that will be divided into subtopic on this. And that will be June 22nd. We then will have significant time before the July 17th period. We'll want to hear from others, but did want to just give, if it's on this same topic, Mr. Dorsey, you've had your hand up for a while, and then we can go back at your discretion. We can also go back to the other members of the subcommittee, as well as our Commonwealth's attorney and our public defender on this on the broad question of jurisdiction and timing of investigation. Mr. Dorsey.
I'm happy to hear other perspectives on that first issue before I take us into somewhere else. Thank you.
Okay, sounds good. So,
Mr. Chair, if I could briefly make a point I meant to make earlier.
Sure.
So with regard to sequencing, that's a question we can get answered. We just haven't done so yet. So it's as simple as talking to an expert about what jurisdictions have done and success they've had in doing it in the way they've done it. So we can get the question answered. We just don't have the answer how others are doing it just yet. That's all.
That's helpful. And you mentioned budget as a piece of it, and so we certainly would engage you further. But Mr. Karantonis, on this topic.
Yeah, just as an additional parameter of that, not to opine on this. There is also an approach that says, depending on the complaint, the sequencing is depending on the complaint. If somebody comes with, racial, ethnic issues or excessive use of force or the treatment of detainee, we could already include the ordinance language that would, guide the priorities here. But I would like to hear about how this would be handled. Also, I'm very interested in what we do with anonymous complaints and what we do with aging of complaints. How far back, for example, a complaint can go.
Sure. So that's helpful. I mean, that is helpful. Thinking about this, which is a complaints originating with a 911 call or dispatch, and not at the death or use of force level, throw it back to Captain Chamberlain, and then I see our public defender, Mr. Haywood's hand as well. First, I think I saw you first, Captain Chamberlain, and if I'm wrong, go ahead and we'll make sure to get everybody.
Yeah, so one of the things in talking about types of complaints, I think, one of the big advances that we've accomplished thus far is our in-car camera and body-worn camera where we've moved in that direction, and it's proven to be quite helpful for us in these investigations. One of the things in particular, in accordance with 19.2201, there is a level of oversight that comes with that piece of legislation that requires us, when there's a complaint of a wrongful arrest, excessive force, or constitutional rights violation, only by a complaint coming from a citizen. We do work with the Commonwealth's Attorney's Office to inform her of that complaint and the investigation thereof. So that does allow her access to those records as well, meaning both the disciplinary records and the internal investigation, if she wants to look further into that, as well as she already has access to the police records associated with that event too. And that in itself is a level of our oversight into some of those investigations that I would think would be quite extensive when we talk about wrongful arrest and excessive force and constitutional rights. So, and that was effective as of March 1st.
Thank you. That's helpful. I think for me anyway, and others may have already seen this, and you clearly know it, 19-2201 sounds like Virginia code, and getting etched in our minds the process that would apply to some of that would really be helpful. And thank you for highlighting that. Whoever, Mr. Schwartz, if you just popped into that, thank you. So that is helpful. And, you know, I've been thinking a lot about the time lag between when body camera evidence is known to have been taken and when it's disclosed. But that's just some thoughts. We may want to follow up on that. So that's helpful, and very much appreciate that. We'll go to Mr. Haywood and then Mr. Dorsey.
Thanks, and thanks for inviting me to this work session. So both you, Mr. DeFerranti, and Mr. Schwartz had actually asked me this in advance about what these investigative models tend to look like, and nuts and bolts, and the mechanics of it, and the sequencing and all that. So I did have a chance over the past week to start researching that myself, both just doing my own research on the internet, but also speaking with some of the experts who are working on this elsewhere. So there are plenty of cities and counties across the country where the civilian oversight bodies do the investigations, where they just do them, and they primarily do them, and there's no concurrent investigation going on with the police department. So there are plenty of places where that happens. The one that seemed to me to have it was the oldest, and they worked out most of the kinks, was Berkeley, California. They've had a civilian oversight body that's been doing investigations since the 70s. Actually, they just also gave that civilian oversight group disciplinary authority. And then also, and speaking with the Legal Aid Justice Center, and I believe a number of you have spoken with them, so they're doing a lot of work on this. And one thing that's super helpful, that I think it'll be very easy for them to do this for you as well, is they created flow charts for a civilian oversight investigation, you know, where there wouldn't be concurrent investigations going on. I've got two for two different other jurisdictions. I'm looking at one right now, but it really just lays out, you know, kind of, and makes it more visual for us visual learners about the steps that are taken. And, you know, I think the first step for all of these where the COB is doing the, and by the way, I call it a COB just because, you know, we're beyond review. So I call it a civilian oversight board, but on a COB, you know, when a complaint comes in, it's immediately sent to the COB. And then there is, as Mr. Karantonis had mentioned, sometimes the COB might have discretion about whether that's something that they re-refer, you know, to the prosecutor's office or to the police department. But generally speaking, they then inherit jurisdiction, and then they are provided full access to all relevant records by the police department, including personnel records, body cam, use of force. Then their investigator conducts the investigation by reviewing those records, interviewing witnesses. If they have to, they can then use the subpoena power for the records and witnesses. They redact records when necessary, but then it leads to a public hearing where the investigator presents the report and findings, and so forth and so on. But there is sort of an established process for this, and I guess that's the basic point I'm trying to make. So I'm happy if you want my help, or if you just want to talk with LAJC yourselves. These resources are available, and it could help make this understand that see the flow chart, understand the flow of it a little better.
Thank you. That's very helpful. I know wherever we end up, for me, it would be visually, in addition to what we've done here, visually a flow chart, I think would be helpful to see. I see a couple of hands. I think Mr. Schwartz and our county attorney, who's also here, acting county attorney, who's also here. And so I think Mr. Schwartz first.
Right. Brad and I had a quick exchange before this meeting, and there's one. The purpose of this session is to lay out some questions that we want to explore further, I think. But one of the concerns that I've heard from some people is that, let's have a little bit of a conversation about if you have a COB or a CRB have an investigation and then they hold some sort of a hearing, how does that involve individuals in the community? And so the example is someone calls 911 and they say, there's a problem, someone's in my neighborhood, I don't like the way they look or what they're doing. Do we want this civilian oversight board to have the ability to subpoena that person to appear in public as a sort of witness in front of the board? I'm not expressing a view on that one way or the other. I just think that's something that you should think through, because that's not involving the police. That's involving an individual who, when he or she picked up the phone, either for good reason or bad reason, didn't think that they would be appearing in that kind of format. So it's a question. And I know Brad's given thought to that.
Good, that's helpful. And that's sort of sticking with the fact pattern that we have here. But acting county attorney.
Oh,
Ms.
Mr. Chair, can we hear from Brad on that?
Sure. Sorry about that.
Or just teed him up and said he'd given some thoughts. I'm interested in if that's all right.
Sure. Thank you, Mr.
Yeah, so this is one where I've got an answer, but it's not my answer. It's an answer from Legal Aid Justice. So Mark had posed this question. I'd sort of asked them what they thought. And I think the number one response was the oversight board is about police accountability, not other citizens. So, say this nosy, concerned citizen calls the police, and then it's clear that nothing actually is wrong. What do the police do at that point? Do they continue to harass the person, or they apologize, or what? So I think that ends up being, frankly, I don't know that it even gets to be an investigation. It ends up being more of an auditing issue. And then the board, depending on how that officer follows up on that, the board can then recommend changes about how police respond to calls like that in the first place. So I think that's one thing. And then also beyond that, as far as what goes on at a hearing, when you have the concerned citizen, I don't think any, and I know this independently also, so I'm not just channeling or parroting what they're saying, but I haven't read in my research, and maybe I'm wrong about this, but I haven't read that these hearings involve testimony. It's more like a presentation. So if subpoena power isn't necessarily to bring in witnesses to testify publicly, the subpoena power would be to access witnesses you can speak with privately. I think it would also be to access documents that you can't obtain because they won't give them to you. But the hearing itself isn't like a public trial. That's my understanding, and I couldn't see any issue with if you do have someone who's made a complaint and it's you're worried about their confidentiality or privacy, I don't see why there wouldn't be a problem just to redact their name. And all of these sort of investigative models do include some provisions for redactions where appropriate. So if that's the concern, that you'd be publicly outing people who did something maybe that was a little embarrassing or regretful, sort of a cancel sort of situation, I think that's avoidable as most of the models that I've seen. But again, that's some of this is just I'm sort of speaking not with full knowledge, so just so you're aware of that.
But as a practitioner, and so that is in the area, so that is helpful. I see Mr. Turner, and then we'll go to Ms. Kaur.
Just briefly, there are some models that will allow for testimony in a hearing-like session, but that's just one option. If you're not happy with that kind of model, don't go with it.
Mm-hmm. Okay, that's helpful, Ms. Kaur.
I don't have any recommendations per se, and I have not had the benefit of reading the Berkeley ordinance, so maybe they address this and I just haven't seen it. But from my perspective, I think the concern I have from just a practical matter is when any given fact pattern comes before you, you don't know at that point if it's going to result in a civil case, a criminal investigation, or any number of other things that might come from it, including a police investigation. So to have multiple parties or entities, I should say, interviewing a witness who are just people, they're going to be subject to witness fatigue, which could then lead to inconsistent statements, not necessarily because they're lying, but just memory and all these other things. It just leads to a level of unpredictability that I think would be difficult, not just for the county or the police, but difficult for everyone to deal with, including the person who's the subject, because they might want to later file a civil suit. And there are all these facts out there, all these different versions of an interview out there. That's just my concern as far as, if you have multiple levels of interviews.
Got it. Thank you. That is helpful I think Mr. Carantonis mentioned a little bit of there's also the thought that there's a requirement that evidence stays in one chain of custody and then evidence could become stale. Those are concerns I've heard. So I don't see hands on this line. So maybe go to Mr. Dorsey if it's a related, unless you may have a leftover hand, or if you have a new point, Mr. Haywood. But I think go for it and let me know. Otherwise, Mr. Dorsey, if you may have another question.
I do. So actually a couple. The first one probably to start with Mr. Turner, given the very helpful matrix that we have of, a sort of tiered approach or a differentiated approach to investigatory authority, I'm curious as whether the subcommittee was able to sort of prioritize really what types of conduct it was most interested in pursuing, and from what angle was there the primary concern that the public's trust wasn't being maintained. So specifically, did it look at all forms of police conduct and wanting those all to be subject to civilian review oversight, or was there more of a concern with activity that would only be subject to internal police department investigations versus ones that would likely result in Commonwealth's attorney investigation or a Department of Justice or some other public body?
That's a great question. Once again, we didn't focus on specific types of conduct at issue when saying you need to have investigations done. What we did focus on, and I'm going to sound like a broken record, and I will over and over again, is what would promote transparency and accountability. And so with regard to whether it's a third-party governmental entity outside of ACPD, would that suffice? Didn't address that question. Doesn't mean that it wouldn't work, though. And also, just for the record, the new proposal, the new practice of having an outside police department or organization do these investigations was not really considered in full, because that was presented to us just a week before we actually made our recommendations. So we didn't have a chance to really fully consider how that would work, and it wasn't presented to us in a fashion to know exactly how it would work. I don't think they actually put their process out and finalized it until this past March or whatever. As I said before, we put together our proposal back on December 18th.
Right. Thank you.
So we couldn't consider that.
Got it. So I see a hand. Go ahead.
Oh, I'm sorry.
Go ahead, Mr. Turner.
No, so the point being, just to make sure I put a dot on this I answering the question. as I've said before, there wasn't a primary concern with use of force because that wasn't what we saw to be the problem in Arlington. But if that were an issue that came up, that would be a part of those things that they could address. But it was more about making sure that an outside body, that's outside the ACPD, could do the investigation and make sure that the community and the citizenry is comfortable in understanding what actually transpired in whatever transaction is being investigated, and that there was little to no bias involved in the outcome of that investigation.
I think that's well stated, and hopefully something that's galvanizing in terms of what we all can agree on. I had another question for Mr. Haywood, but Mr. Chair, I don't want to subvert Mr. Karantonis if he wants to sort of continue in this area.
Mr. Dorsey, can go ahead. I mean,
Thank you. So, Mr. Haywood, I don't know if we're in a work session. We're both casual. Brad, I don't know if you've had a chance, when you've looked at some of these other models, specifically the Berkeley thing that you referenced, to see how it works where you've got an oversight body that does the primary investigation into conduct and then makes now decisions about discipline in an environment where presumably there are grievance procedures when, public employees are subject to a level of discipline. Do you have a sense of how that all works?
I know a few things, a few important components. I know that that there's generally speaking, there has to be an appeal process. So that's one layer of due process that they get. I also know that as far as when you have the oversight body doing most of the investigation, that does result in the police department's internal investigations. They don't need as many employees, but they still keep an internal affairs department to deal with things like that, like what do you actually do when misconduct is founded, or also to deal with misconduct that maybe doesn't fall under the purview of the civilian oversight body. But beyond that, I think that's sort of the extent of my knowledge on that point.
Okay, appreciate it. Thank you.
Mr. Karantonis.
Thank you, Mr. Chair. Just a general question. Was during the deliberations of the, on this subject at the police practices group, was there consideration of a triggering event that starts an investigation without a complaint? That means when the majority of the board or the civilian oversight board says, well, we feel that we need to investigate this. Was that discussed?
Without reviewing my notes, it possibly it was, and so this may be me taking a step back. When I say the investigations begin because of a complaint, that was what we contemplated to be the case. Now, is there circumstance such as last June 1st of 2020 that's so public in nature that could this body initiate something on its own? Sure. But once again, we didn't get into the granular details about operational procedures of this body. There are other jurisdictions, and once again, I try to base my thoughts on what I can look at and what I can sort of look and review. Other jurisdictions have that authority. They're not solely tied to receiving a complaint, because I can imagine certain circumstances where the person who would be in the best place to complain would not be available to complain. Not a lot of discussion on that point, but I can envision that being an avenue toward an investigation started by the COB in that manner as well.
Thank you, Mr. Turner. I see, and Mr. Karantonis, I see, Latasha, your hand is up again.
So, in regards to a couple of things, one of the questions you had was, where do investigations generate from? And a large number, more so the majority of our investigations are not from citizen complaints. our investigations are generated internally and the accountability of how we hold our staff accountable. So one of the things was part of my input to the subgroup would be that the CRB would review and in an attempt to see how it impacts public trust because of that reason is investigations that were considering conduct unbecoming constitutional rights, integrity, accuracy of information, bias-based policing, and harassment. And those allegations in those, because those are that's what we're made of. And that impacts public trust if we're not able to uphold that. And that to me is where our transparency level needs to be communicated so the community is aware of how we hold ourselves accountable. These were the allegations, this was the investigation, and this was the findings, and whether or not that CRB concurs with that report or not.
So that's very helpful, and it's consistent with my recollection. One of the last 2 years that there might have been, in a good majority of the complaints that I was and concerns that I looked at were within the police department to make sure the fellow officers were following all policies and procedures. So that's helpful. We've already started to move into the next two scenarios, the next couple of pages, and I see Ms. Crystal, maybe go ahead with your question and maybe we can start to move along. But one sort of between Mr. Turner and Ms. Chamberlain's last two, Captain Chamberlain, your last 2 points, transparency and accountability is a theme, and at least I'm initially attracted to something that enables a short period where there could be perhaps Office of Professional Responsibility, and then but a sort of time period after that in terms of days when, for transparency, if there's, say, a majority or 2/3 of the CRB that wants to investigate, that in those circumstances something could move forward. But Ms. Crystal.
Thank you. I am realizing, actually prompted by those good comments about the other ways in which investigations under the current system originate, that there's actually a bucket beyond the three we've teed up here, which is the bucket beyond investigations at all. And I know you all recommended to us, among you all being the PPG subcommittee, recommended to us that among the responsibilities of this group would be to advise on policies and procedures, and specifically review and make recommendations about ACPD policies and procedures. And so it may be best to sort of punt that question to the end and we can maybe flesh it out a little bit, but I'd love to hear more from you all. And I think just to tee this up, this may be one of the questions that we really want to ask the broader public at our listening session. But is there any more you tell us about what that responsibility looks like, where we homed in on investigations because this is the topic that's maybe gotten the most heat and light in our community, but that's an important piece too, is reviewing policies and that policy oversight and recommendation. So I'd love to hear more about what the PPG meant and see a couple of hands.
Yeah, there's plenty. Mr. Schwartz, did you want to clarify, or should we go straight to Captain Chamberlain?
Real briefly, because I have talked to a lot of the people, not everyone on the call, about this. One of the actual core functions of CRB or COB, or whatever we're going to call it, needs to be able to reflect on I would say, larger questions and patterns and things that they want to sit down and explore. I'll call it the audit, more of an audit function. And we have an auditor monitor. That is one of the core things that, and I know it didn't get a lot of attention, but it's one of the core things that's included in the proposal I have made. And it was not my idea. It came from the PPG, which had done that. And I know I've talked to the police chief about that, that's something that we really welcome. I think that we don't want to scare off potential members of this board, but they will have a fair amount of reflection and thinking to do and advise on policy.
Thank you, Mr. Schwartz. We'll go to Latasha and then to you, Saul.
So in regards to Ms. Crystal's comment about policies and procedures, we took our first stab at that when we looked at the body worn camera, or in its totality, the digital evidence management systems policy. And that policy was put out to the community to give feedback on that policy. And we took a lot of those comments and the statements associated with that to make sure what transparency meant to them, and also how we can hold ourselves accountable, or how they believe our accountability would be better with changes into that policy. I can say that with a lot of confidence that we made a lot of those recommendation changes because of that. And so I do think moving forward, when we do have these policy matters and we consult the public of what they think and feel about it, we'll be able to get good feedback on them and how that transparency is there to ensure that we're meeting their standard as well.
Great, thank you very much. We're seeing why you guys spent so much time together working this through, and we're lucky for that, even if the time period, as Mr. Schwartz identified, has been extended a little bit for added service. So,
yes, while we're on the subject of trust, transparency, and accountability, I think that the CRB can show that and ensure that to the community, to the public, through it being considered a CRB to be proactive, as well as Ms. Crystal mentioned, advising on policy and procedures. One of the things that they could do to be proactive, to look at what needs improvement. And those are one of the things, just being proactive, and also looking at trends and things that are happening either locally or regionally or in the nation. So to show that it is proactive and that it is here for the community, and definitely different situations will have to be considered as situations that may be present now or may not be present now, but could be, susceptible to in the future. So in that regard, I think that the board could also be proactive in analyzing things that could become a problem later on in the future.
that's very helpful. We've given ourselves a little, an additional topic that needs time and energy. So, but it is helpful. And I see Mr. Dorsey. Go ahead. And then Mr. Haywood.
I do see Mr. Haywood. If he wants to speak to this issue, mine's going to take us in a different direction.
Go ahead, Brad.
Yeah, so I think I've told you, Matt and Mark, this, that I do think that the auditing function of the civilian oversight body is the most important in Arlington, because, well, for reasons that were just stated about being proactive, but mainly to me, and it's no secret, I think that the issues with our police department are mainly at policy level. You see the racial disparities in traffic stops, for example, or incarceration, things of that nature. Those are policy related. That's not specific misconduct that any police officer engaged in. It's just a practice. Whatever they're being told to do apparently is resulting in these things. So that's going to be super helpful to have that auditing function. But at the same time, this is why I don't really completely understand, to the extent that the police department is not in favor of civilian oversight-led investigations. I don't really understand that, because I think that the real benefit of having an independent body doing the investigations is that's how you increase trust with the affected communities. If you continue to do it in-house, then there's going to be that continued distrust, like, what's really going on here? Are we really getting the whole story? Whereas if you allow an independent body to do it, I mean, this might sound surprising coming from me, but I think the vast majority of complaints are going to be found. It's going to be found that the police officer did not engage in misconduct. I really think that's probably going to happen, because I do think that our police, despite the flaws I just mentioned in terms of policies and practices, I think they're generally professional in the way, that American police are very professional. And I think they've been trained well enough not to hurt people most of the time. And why would, if that's really the truth, and the police department's confident that they're doing their jobs appropriately in that regard, then you would want somebody from the outside to do that investigation, who could then say, oh, look, okay, fine. Yeah, I've got all these documents. I've got access to all the witnesses. And this officer seems like he did a reasonable job. And then not only is your department looking better, but also you're building trust with the community, because that investigation and that's that imprimatur on the quality of their work is being done by someone outside the department. So I really actually, that's, to me, that's the why both are important. And yeah, that's my take on that.
Thank you, Brad. That's helpful. We'll go to Mr. Turner, and then I see Ms. Garvey and Mr. Dorsey.
Just briefly, I just want to echo the point that Mark raised, or Mr. Schwartz raised, about the importance of the auditor monitor. And as I envisioned it, the auditor monitor would often surface the issues, and the COB would have a chance to sort of ruminate over them and then come back with recommendations as to how to improve policies and procedures at ACPD. So thank you.
Thank you. That's helpful. Mr. Schwartz and then Ms. Garvey.
Brad, I'm going to have to take you out to coffee so that you can understand there actually is a different point of view. I'm not actually disagreeing with your point, but transparency is incredibly important. I think that's a different question as to who does the investigations. I'm just going to say that because I think there are distinct issues. So I, for example, could be in full favor of transparency and rigor in investigations. Doesn't mean that I think you need to have two separate groups. I didn't say you were advocating for that, but I think you can actually have a group of people in the police department who we actually have an external party right now analyzing all of the IA investigations, is going to come forward with an analysis of it. If they're great at what they do, and I think they are, then I think that I fit your definition of excellence. But I'm just doing that to be slightly ironic, but I just wanted to respond.
Thank you, Mr. Schwartz. There's the function of transparency and accountability, and then there's trust of those who are doing that, which is distinct. It could be distinct. Ms. Garvey.
Yeah, thank you. So I think it's really helpful, and Mr. Turner is when I kept bringing it back to trust, transparency, and accountability. I think as we go through this to make it clear what we're all trying to get, what the goal is. I think we all have the same goal, which is really helpful. And then I have a question. I think it's for this, and I know you want to move on, Mr. Chair. It's probably for each of them, because one of the questions we have is, do we do investigations sequentially? Or do you do them like both at the same time, concurrently? I think that's some of what we've been talking about and that Mr. Haywood has talked about. And I'm not sure why a sequential investigation might not yield the trust, transparency, and accountability. I actually think in many ways it could be better, because if you got two investigations going on at once, it can get, I think Min Chao talked about it a little bit, it can get kind of all mixed up. Whereas if you do one and then the other, and the second one is to look at how the quality of the investigation is done, that feels to me like meeting our goal. So as we kind of go work through this, I'll be interested in people explaining why it might not, if that helps. Thanks.
That does help, and it sort of gets back to the original question. I'm mindful that Mr. Dorsey has been waiting, and we want to just we see our Commonwealth's Attorney, Ms. Dangani Tafti. You had a thought here.
Just to point out that we've been talking about investigations as if it's sequential, then there isn't going to be sort of true investigative power. It's not. There is a model where the investigation is sequential, and the second the oversight board is not just looking at the other at the IA investigation, but actually able to generate documents and speak to witnesses, including the folks who did the IA investigation, so that it is really performing an oversight function of not just the individuals that had the complaint against them, but it's an oversight function also of the actual IA investigation.
Thank you. That's kind of what I was thinking. Thank you. Thank you, Percy.
That's very helpful, because it's almost, and I think this is not my insight. It might be yours, but it's the function could be investigate the investigation. That could be a piece of it. I will say, from a timeliness standpoint, this is related to body-worn cameras, but in the popular, maybe it just sticks in my mind is, Mayor Emanuel years ago delayed a body-worn camera for well over a year for political purposes. So I see at least an argument that that two investigations at the same time could cause trouble, but there might be a timeliness. Evidence does get stale, and so there's a lot of polls that show that the same thing can be described different ways down the road. But as people lose their recent memory of what's occurred. So I don't know if this is on the same topic, Mr. Karantonis. Go ahead, if so.
It is, and I just wanted to say, I mean, we just recently saw what happened in Windsor, Virginia, right? The Karen Nazario issue. It took like months to get this the footage out. I mean, this would the issue here is whether it would be advisable that the board could opt for a contemporaneous model of investigation. Whether the board should have the ability to launch that. It could say no and say, no, we are satisfied by, the first tier investigation that the police department does. The question is, I wouldn't like the board not to have this ability. So that's the point.
Sure, and this really gets back to two thoughts. Mr. Turner made the point about budget. If we have this full amount, the cost could be more. And it's also, what are the trade-offs between budget and what we perceive and to be in terms of trust, and also in terms of our police department, the challenges. And I know that there's, to my knowledge, in the past 20 years, there's been two big force issues, and there are different opinions on those, but at least I do not believe we have an abusive force problem. On the other hand, I think that there is some evidence that our policies are leading to disparate impact in terms of traffic stops, which, the problem may be related to how we structure the solution of the civilian review board or civilian oversight board that we structure. But I think over to you, Mr. Dorsey.
Thank you, Mr. Chair. A lot to say. I'll try to sort of figure out where we are in the conversation. But, as we've talked, at least on the criminal liability sort of bucket, and I'll use the specific example of law enforcement involved shooting. We have, two dueling alternatives. So there's one, a question on the substance, and then two, what's within scope for our county attorney. We viewed it as either concurrent or sequential. Is there a third way? And, really inspired by Mr. Turner speaking about trust. We want trust in institutions. We want transparency. And I at least know that in the District of Columbia, kind of the way this works is that the police department investigation of something like an officer involved shooting will include bringing that civilian oversight body into the investigation in terms of, here's what we're going to be looking at. Here are the questions that we're going to ask. Do you have any feedback, insights into this? They share general results as they go along, and the oversight body has in real time the ability to say, you didn't really spend enough time with that witness. They never got comfortable, or you concluded the interview before you really got to the good stuff. There was almost this collaborative model of doing it, so you weren't necessarily building these big bureaucracies to do redundant work, but you're overall promoting this whole idea that the system works, and that's really my interest, to make sure we get a system that works well. So I'd love to hear some thoughts on that, just substantively, and then for our attorney to think about is whether or not we have room within our scope through the MOU or some other mechanisms to pursue a more collaborative model than just simply either or.
So that you stumped us. So I guess the first of those questions, I don't know, maybe we want to hear from our community first Go ahead, Mr. Schwartz, and then we'll hear from.
I would just, Christian, thank you for your question. If I pop up the outline, which I've been trying to avoid to do because I want to see all of your faces. If you look, I now have it on the page. If you look in the right-hand column, lower right-hand side, and I'm going to try to highlight it, I think that in that outline, we spoke to the question you raised, Christian. If we could actually, this is even more than what they allow in Alexandria, we could allow the auditor monitor, not the full civilian review board, this would be my suggestion, to sit in on briefings and questionings with ACPD to the extent that the Commonwealth's attorney is comfortable with that during a criminal investigation. And the auditor monitor could suggest avenues of inquiry and keep that information as a representative of the civilian review board. And then when the criminal investigation concludes, could disgorge all that information as quickly as possible to the civilian review board to make sure that there isn't that conflict. I mean, I contrast that with Alexandria, where the auditor monitor is sort of briefed on it, but isn't actually even allowed to be, as I can tell, be in the room. This is something I've talked about with the police chief and we're very comfortable with. We haven't talked to the Commonwealth's attorney about it, but I hope that gets to your question.
Thank you. Thank you. It gets a lot of the way there for sure.
And then, so just looking at hands, I mean, so perhaps Mr. Turner, and others of the police practices group would be interested in your thoughts, but it doesn't have to be today. Because that collaborative approach, you mentioned Atlanta, Denver, and other locations, through the Legal Aid Justice Center, I've been learning a little bit about Charlottesville. The truth is that in Virginia, to my understanding, Richmond, Charlottesville, and Alexandria are the ones most working on it. There's one in Virginia Beach that is somewhat or not robust, I guess I would say. So, I had not heard about DCs. So maybe there doesn't seem like a clamoring. It's a great question, Christian. I don't know that there's a clamoring of we know the answer yet, but maybe that's something we want to follow up on. Mr. Turner.
Sure. So I think that's a great idea that Mr. Dorsey raised. And so in spinning through these, there's one model in Seattle, they call it civilian oversight, but it's actually housed in the police department, and they do the investigation. And they work with IAD, I believe. But that sort of is, given that it's housed in the police department, I don't know how much civilian oversight it is, but they call it that. But that sort of speaks to the collaborative effort. With regard to what Mr. Schwartz has recommended, I just question, I don't know how many investigations are ongoing each time, but how thinly can you stretch that auditor monitor to sit in on all those investigations? And I would need more information to understand how viable that option is. And with regard to the phrasing, to the extent that the Commonwealth Attorneys allows ACPD to be involved, I don't know what those limits are. And so in as much as if that model allows for the auditor monitor to provide input, maybe not necessarily ask questions, but provide input into how the investigation could be done. Mind you, as a former investigator, I would hate that personally, but still, if they can provide input, I think that provides more of a useful model along the way. But once again, with the caveats, how many investigations are ongoing? Could that auditor monitor do that effectively? And what are the limits of that? Thank you.
Sure. Thank you, Rodney. So I think Ms. Phillip, your hand is up. Are you there? Kim.
Hi, I am here. And so my question actually is a follow-up on Christian's question and Rodney's response. And having that auditor monitor sit in on the briefings. If I were a member of that civilian oversight board, I would want to have the opportunity to just ask, how is this investigation going? I've got some questions I'd like to ask as it's going on. And so it's not just the investigation is done and then and then the oversight board basically hears, this is what happened and this is the resolution. But a more collaborative approach where the auditor monitor can then go to the civilian oversight board and say, this is what's going on right now. What questions do you have about the process? Do you have additional questions that you would like to have asked? And just keep that collaboration going on through the investigation.
That's helpful. I mean, I also know that one of the questions asked as far as trust building is the proposal is with the auditor monitors reports directly to the manager, and your line of questions, Kim, there would be, you know, involving there is a possibility. I know some civilian review boards report to the board. We do have a different form of government, so we'd have to work through those issues. But the informing of the civilian review board that you mentioned, formalizing that could take some additional work. I guess, you know, I think that there was, Mr. Dorsey, you also asked a question probably for our county attorney, I think, on the scope.
I think I know the answer, but I want to make sure before I get comfortable. So.
Do you need?
Okay, so the question is whether it's in scope to have this collaborative approach. And if it is done through the MOU, then certainly it is, because it's the MOU, it's not the ordinance. But if you want to do it through the ordinance, it is outside of the scope.
Right. Huh. But theoretically, as this discussion has gone, that is something that could be effectuated within an MOU, correct?
Yes.
That's helpful. And we will have to come back to the MOU. As we're sort of moving through this, I'd want to go, Ms. Tafty. Dingami Tafty first.
So the point that I was trying to make earlier was just making sure that the subpoena power is preserved. And the reason why I'm asking this question right now is, with the collaborative model, would there be subpoena power, and at what point would there be subpoena power?
So to me, this would not limit the civilian review or oversight board's authority once the process is concluded to say, you know what, we didn't really like this in totality. You know, we want to take a further look, or we think that it was inadequate, and they conduct sequentially their own thing under the model of taking advantage of everything that was done and doing their own thing. It would not change that at all. But, you know, it's again, you know, one of the things that I think has been lost in this larger conversation is that we're trying to change systems, not just to remediate its incidental bad acts. We're trying to fundamentally reform systems. And if you want to build trust in a system, you got to make the system better from beginning through the end. So you just can't, in my opinion, take a position of we're going to solely position ourselves to punish people when they screw up. You've got to structurally allow yourself to make sure you don't screw up in the first place. So that's all this is intended to do, not to limit subpoena authority or the ability for civilians to take a look under their own desire once another investigation is concluded. It's to sort of layer the collaboration at the outset and at the beginning without changing anything else.
Okay, so I think that may answer the question as to subpoena might still be there, but how it would be used could vary, at least the way I'm hearing it. So depending on how you structure the process. So Mr. Karantonis.
So the way I've read about civilian review boards, there are some civilian oversight boards that, for example, there are provisos when that the board has to be informed, reported to, if a weapon is discharged. If an officer, for whatever reason, discharges his weapon, this needs to be reported within 24 hours to the board, and the board has to decide what to do after that. Same if any other weapon is discharged, or if injury occurs, etc. So would this be a trigger for this collaborative approach that the auditor monitor would then, be immediately engaged in the common investigation, in the department's investigation of the discharge of the weapon. And is that viable through the ordinance as it is today, or is it within the scope? Or would this be again an MOU issue?
Let's see. So you've raised a very specific, important question. Go ahead, Ms. Crystal.
Well, I was just going to say on that topic, I mean, I know as we sort of think about moving to these other scenarios or fact patterns, we know, for example, with instances in these sort of second buckets, potential civil liability or criminal liability, that when a weapon is discharged, there is a use of force investigation already underway, right? That is, or it is already policy of the police department to begin a use of force review. So I was just going to say, by way of answering that question, I am in learning mode, right? I don't have any philosophy on the way to do it, but I do wonder if it makes sense to kind of transition into some of those fact pattern cases, because this is an area where I think I would benefit a lot from hearing more from our Commonwealth's attorney, our public defender, potentially others, just about, when you're at the point of a potential criminal investigation, certainly in a use of force scenario, how do you see a civilian review board effectively overlapping with your work as you decide, how and whether to build a case, for example? I don't want to put anybody on the spot, but this is sort of a body of work or a body of instances or fact patterns in which, I would love to just kind of hear more about how the CRB, the auditor monitor, overlaps not just with police internal affairs, but with other elements of our justice system that may kick in when a weapon is discharged or a use of force scenario occurs.
Great. So I absolutely, let's move to the second scenario, but I think, Mr. Turner, I don't know if you had thoughts there.
I do. And so I want to remind everyone, first of all, Arlington to be commended to voluntarily approach this issue and to put something forward. But when you look across the landscape of the U.S., many other jurisdictions had to be compelled to do this. And because of that history, often they come up with these very stringent requirements as to what gets reviewed by the civilian oversight body. And so there's a history behind why they say, hey, if a gun's been discharged, you got to notify us within 24 hours or whatever. So we could obviously do that. The question is it appropriate for us? And so that's it.
Great. Thanks, Mr. Schwartz.
I'm not going to answer Katie's question directly, but I do think it would be helpful if we heard from Captain Chamberlain and also Parissa and then Brad about what happens right now when a firearm is discharged and there's a potential criminal investigation, because if you want to add something on top of it or next to it, it's good to know how it works right now.
Go ahead, Natasha, Captain Chamberlain.
So the current process is the event occurs, the criminal investigation begins immediately. The Office of Professional Responsibility investigators, they do not engage because that is the secondary part of the process. What we will do is view the interviews, anything that's happening live post the actual event. Therefore, we will sit and view the questioning of the officer or any other witnesses. And then from there, once the investigation has concluded, that investigation from a criminal aspect gets turned over to the Commonwealth attorney. And once the Commonwealth attorney has decided to prosecute or decline, then the administrative investigation within OPR then takes place. During that investigation for OPR, it's a use of force, obviously serious bodily injury investigation. And then from there, we will be looking at any policy violations, any mitigating circumstances that even may have been able to prevent the interaction. So where the critical incident response team comes into play now, when that goes into effect, they will then take over the spot for the criminal investigation, which will still allow the internal affairs section to sit in to view that interview. And generally speaking, if there's questions that the internal investigation is wanting that we're missing, we can throw those questions at them. The way that I think from the conversations that have been out here, in terms of the auditor being included, I think that would be a good opportunity for them to sit in with IA as they're viewing those interviews, so that if they have questions or believe that the line of questioning is not giving them the information that's needed, they can then give a forthcoming questions to the investigators, the criminal investigators. Because at this time, these are not compelled statements. This is because it is a criminal investigation.
Okay, that's helpful as to how it proceeds. Thank you, Captain Chamberlain and Mr. Schwartz, for sort of helping us understand how it would proceed. I'm looking, it might help just for a second, if you're still willing and able to do it, Mark, if you're able to pull up that second page, the scenario, just to kind of allow us to look at this a little bit. And certainly, I know that your question, Ms. Crystal, also, or I think the question also was ready for thoughts from Brad and Parissa as well. And I was thinking more of the spreadsheet, if that makes sense.
Do you see it now?
I do. Hang on just a second. My screen is freezing for a quick second. Yes, so Mr. Karantonis asked about, I think, a gun firing a shot. And I think the example that is on the left side here is police-involved shooting. I think those are slightly different. At least it implies to me police-involved shooting that contacted with a person. But it would be a little different of just if a gun was discharged in the line of duty at all. So those are a difference. And then if you look at the various proposals, the overriding question is, how do we avoid undermining prosecution and creating conflicting witness criminal statements? And so that, I think, is a challenge that we will have to consider more. There's a couple of provisions in this, in the advertised alternative, as well as the county manager proposal. There's also the question of how the MOU would work. The auditor monitor could provide additional oversight. The question of, or additional insight, the question of how that would be perceived as far as transparency is also relevant in addition to the function of oversight. But this kind of, that kind of covers some of the questions. The phrase in the second column, the bottom phrase, subpoena power will not unreasonably disagree with a protective order. I'll just sort of share that seems, if you get a protective order from a judge, having an additional standard that is unreasonable disagreement seems more protection than the transparency that a subpoena could be worth. But Mr. Dorsey, I see your hand.
Well, I just wanted to say from my mind, I know that we've sort of embodied this whole concept of sitting in, at whatever stage in a collaborative way as being vested with the auditor monitor. There's no reason why it could not be any other investigator who is contracted or employed through the CRB. I think that would be up to them, not necessarily us, and wouldn't be seeking that level of specificity at this point, because I think you bring up a great point. It may be in the public's best interest that, there be some other designee there. And I'm not sure that I would necessarily want to dictate that from the ordinance level.
Got it. So that's sort of indicating that there are more, that we're adding questions in addition to understanding the process a little bit better. Are there any other points that people wanted to bring up on the criminal liability, including death or use of force? For me, this again, the Windsor example is relevant, and this is where it would benefit me to understand better the Virginia statute with respect to body-worn camera evidence, if there is a separate provision. So I'll have to look at 19. Code section, Virginia Code Section 19, which Captain Chamberlain mentioned. So there's also, I kind of want to move us into, there's a third area, which is potential civil liability, and this is where the attorneys could be particularly helpful. Criminal liability, it could mean the incarceration of an individual, and civil liability, there's significant financial resources in play for civil liability. I guess in some ways you could argue this is somewhat more similar to our discussions of investigations and policy investigations. But I don't know if there are questions on the civil side of things. Again, for me, there would be a time amount investigating whether the investigation has proceeded appropriately is relevant for me. And I'm also attracted to the idea, if there are concerns with respect to the 2/3 majority, I think could be used as well to determine if the review board should move forward, which could be a protection to make sure that there's credible facts that are worth investigating, but also the ability to issue a subpoena or seek evidence in terms of a civil or criminal investigation midstream. The main question, and then I'll put this to everyone, how can we avoid creating conflicting records, witness statements between civil litigation and a CRB investigation? And so I want to put it back to our police practices group and Brad and Parissa to see if you have, I guess I'll put a finer point and say, is it of concern when you have a time lag between an incident and the investigation that reaches 9 months, a year, 2 years? Is that another item in addition to the 2 investigations at the same time that could be of concern as you build a case or as you work on a civil case or criminal? And we don't have to answer it all, but
I think
will
you've got
tell
at
you.
least one hand up, Matt, from Brad.
Oh, sorry, I didn't see your hand. Go ahead, Brad.
It's hard to see with the shared screen.
Yeah, maybe we pull it down. Thank you.
So you're just specifically asking about if there's a civil case, about civil cases at this point, because I also wanted to chime in about pending criminal cases.
Both of them, and the time lag question.
So with respect to a civil case, when I was in private practice, I actually did some 1983 cases, so police civil rights cases, or use of force type cases, and those aren't generally speaking, you're not going to file that for a long time. There's a statute of limitations, and you're going to generally use a lot of the time that you have to prepare the case before you ever file it. So I think generally speaking, the complaint, the internal affairs complaint is going to, or COB complaint is going to be filed first. It never dawned on me that would be something you would prioritize, a civil case. I mean, so many of these are not going to be actionable in a civil trial anyway, because they're not going to involve actual damages. In Virginia, that is often preclusive. And if that's not preclusive, then qualified immunity often is. That said, the other thing I guess I just wanted to bring up was some of the dynamics that are involved when there's criminal charges. So one common complaint about how police investigations proceed, and I think some of this is unavoidable because of the Police Bill of Rights, but there's a circling of the wagons that goes on. Police have essentially a much greater right to counsel than your average defendant does. They're given plenty of time to talk to lawyers before they ever have to talk to investigators. They're given the opportunity to receive advice from lawyers. They very frequently are given opportunities to speak with their colleagues, to get their stories straight. And I don't know, honestly, how avoidable that sort of thing is. I haven't seen any models for civilian oversight where the civilian oversight body is allowed to investigate a complaint if charges are brought against an officer or if they're investigating criminal charges. I haven't seen that. I don't know if that's even possible. I do think, however, that it's important for complaints, for the oversight body to be able to investigate complaints if there are certain charges, if there are charges pending against the complainant, and especially if those charges involve basically it's an offense against an officer. So because this is something that's also very common. This is if in cases where there's a use of force by a police officer, that often oddly results in charges against the defendant. And it'll be something like obstruction of justice, resisting arrest, assault on a law enforcement officer. And that is, cynically, but this is true and it happens, those charges are sometimes brought so the police can insulate themselves from potential liability should that person desire to file a civil, a lawsuit. And one of the reasons for that is if you are able to get any conviction from that incident, if a police officer is able to get any conviction, so even just a misdemeanor, that almost completely precludes any ability for that complainant to win a civil case. So that is something that happens, and I don't, if that happens, I don't think it's essentially keeping the civilian oversight body from investigating because a charge was brought by an officer. I don't like that dynamic. Is something I would want to avoid myself. So I just wanted to raise those points.
You're on mute.
Mark, you're on mute, yeah.
My time, and I was encouraging Mr. Turner to jump off mute while on mute myself. Go ahead.
All right. So I have a question for Brad, actually. So you mentioned you were you represented some of the 1983 claimants. Would you, in that position, allow your client to speak to a COB for fear that it would maybe impact your case?
I can think of one that happened. I won't give away any details that would disclose who this person was, but basically the police officer tried to stop him for trespassing in a park after hours. It wasn't after hours. He decided to run, which actually was his right given those circumstances. The officer chased him down, tackled him, then tased him 5 times, and he spent 2 nights in the hospital. And the officer did charge him with obstruction of justice, resisting arrest, and it was a big deal. And I think those charges ended up being dropped, but he had that decision to make. I think he had to sort of roll the dice and decide whether he was going to have that criminal trial or not. And then we got the case after the case. He had a good lawyer, and the case did get dropped. So then we got it as a civil case. And I think I would. I think I would definitely allow my client in those circumstances because he was telling the truth. Like he absolutely was telling the truth. And if he has the guts to bring a civil case, he's going to be subject to depositions. He's going to and interrogatories and all that sort of thing. So I'm going to have to stand by his story regardless. And I think that if you've got a civilian oversight body that's doing good work, that is independent, that's reliable, trustworthy, all those good things, I think I would let that happen.
Thank you.
God, that's helpful. Go to Ms. Kaur and then Ms. Tafty.
I think you've already gotten a preview of what my views are in this, and I'll just repeat it. I do think it's a concern to have concurrent or even sequential investigations and how it would affect civil cases, because it's the same issue. Whether you go sequentially or concurrently, there are still two entities creating two separate bodies of evidence. And like I said before, they're not machines. They're not going to spit out the same story each time. It's not because they're lying. It's because of memory issues or because they're fatigued. They might have been interviewed about this same issue 4 or 5 times. And maybe some of those inconsistencies are, fine, and they're really not going to impact the case, but you don't know that. And it's that level of unpredictability that creates real concern for me for civil cases. And I'm not just saying that it's going to create concern because it prejudice my case, although obviously that's a concern, but it could potentially prejudice the plaintiff's case as well. The problem with unpredictability is you don't know how it's going to affect the future cases. So that's always going to be a concern for me. And I will disagree with the idea that it's not really a concern for civil cases because the police have qualified immunity, or people don't typically bring their cases until years later. Most of the cases that are brought against our police officers allege gross negligence. They don't just stay with negligence. And so qualified immunity isn't a complete barrier. And so it's not a non-issue. And we don't always see people waiting until the full statute of limitations or even close to it in order to file a civil case. I'll give the example of, the cases that were filed as a result of what happened in Lafayette Park. They filed the day after.
Mm-hmm. Got it. So that's helpful, and we can maybe we can come back eventually to the question of whether long delays before an investigation. I guess there could be federal criminal investigations, but you were focusing on the civil side. But appreciate that, Ms. Cora and Ms. Tafty.
Does Ms. Cora have anything else to say? I'm sorry.
No, I think it's over to you.
Oh, okay. So the thing, I don't mind the idea of a auditor monitor being in on briefings and questioning to some degree, but as a practical matter, that actually allows them more access than the Commonwealth's Attorney's Office has had. So we're not that physically involved in the investigation at every stage. I mean, certainly we get briefings and we ask, we ask investigators to do certain things, but I'm a little uncomfortable with giving more access than we even have. And the reason why we don't actively engage in investigations ourselves, is because, qualified immunity doesn't cover us for investigative functions. So, we're when we are out, investigating ourselves, we are sort of opening ourselves up to some civil liability. So I'm like at once uncomfortable with it because it's more than we get, but I'm not sure how much I'm willing to insert ourselves actively into investigations. I mean, we don't sit in on interviews, for example, but we do, if we know somebody is coming in for an interview, sort of discuss what we want asked and what information, and then we certainly send folks back to gather more and that sort of thing. The other thing that I'm struggling with is because there aren't very many models of the sort of prosecutor being having this kind of oversight is what happens given that that sort of as the constitutional officer, my office has a responsibility for making these decisions ultimately, right? The police mostly do the charging, but in the case like this, when we're talking about this, we would be making that decision. If the auditor monitor or the civilian oversight board disagrees, I'm not really sure what happens. And so those are questions that I think we need to talk about. And it could be, it could be disagreement in either direction, right? We bring charges and they disagree, or we don't bring charges and they disagree. And sort of what happens under those circumstances is a question that I think we need to nail down. And in terms of the collaboration does help reduce the number of versions of a story. But the collab, like even the way that you ask questions can formulate people's memories, and can shape people's memories. And so that's just, it's like, if we're worrying about different versions, we should also worry about cooks in the kitchen. So, those are both the sort of, I mean, I haven't really answered any questions. I've just posed additional issues. And, chain of custody is a really important thing. And I don't know that anybody is suggesting that someone show up at a crime scene and start collecting evidence or anything like that. But I just, want to make sure that whatever is decided, we are still able to prosecute a case because we still have the appropriate, sort of the chains of custody that we need and the presumption that comes with who's collecting the evidence, and that sort of thing. So I would just want to make sure that whatever collaboration happens is one that doesn't interfere with the actual ability to prosecute a case.
That's spoken as someone who's far more in it than I've ever been, and most of us have ever been. So you're raising additional questions. I see Saul's hand. I'm going to propose, we had this calendared for more time, but I actually think it might be possible that wrapping up soon and then following up may enable us time and space to work on this a little bit better. But I do want to make sure we're listening and hearing all perspectives. Saul.
Thank you, Matt. I just want to say that in doing this, Arlington County is being progressive in putting this forward and being creative, finding new ways or enhancing processes that are being taking place in other jurisdictions as well, but just making it better here for Arlington. I think that the idea of the collaborative function is interesting, but I think that there is the one concern I would say, and actually a benefit also would be that the auditor or monitor can provide and may be able to help pick up on the things that may get missed or give some ideas in an investigation, but. I think that we will hear a concern within the community about authority is, would any authority be hindered? And with that authority, what authority could these auditor monitor have given provided by an ordinance versus the MOU? And as I mentioned, that what you'll hear from the community is the concern of limiting authority, which is provided by the state, and keeping in mind that what's important to keep in mind is that we're in a Dillon rule state, and as you all know, that fact limits what authority local jurisdictions have, and in that regard, the state is allowing localities to implement a civilian review board with the authorities that we've discussed, subpoena and investigative. So that is just my question. Would any authority be hindered in this collaborative scenario of proceeding with this? I don't know who could answer that
Sure.
question.
I don't know enough about the DC system, and what we do know from Ms. Kaur's answer is that that would have to be worked out under an MOU because we didn't advertise such that a collaborative would work. But Christian, go ahead.
Yeah, I'm just going to opine because I think Saul asks, a question that's on the minds of a lot of different people, and just sharing opinions. I just don't view it that way. The state permitted something broad, which is, I think, the responsibility of a state that denies local authority. I thought that's a good thing. Just because they permitted you to do something broadly doesn't mean that's it's most responsible for you to do something that's as broad as they outlined. So, I think one of the things that's gotten lost in this conversation in Arlington, or at least from my mind, has been unfairly presumed, is that doing something different than what is permitted in the ordinance is somehow less than or a weakening of community protections. And we're Arlington, so we're taking everything to the wonky level. But we could have taken an approach where we just adopted something that looked very much like what the state permitted, and then left it to having all of these really meaningful conversations down the road when you get in practice. We're just choosing to have those conversations at the outset. So once we do it, this works well, and it's hopefully not the shit show that it is in many other communities. So that would be my 2 cents on it. So
got it. So we've heard technical terms of gross negligence and Mr. Dorsey's recent term, but I like it. And we have Brad and Takas. I think Brad was first. Takas, if that's okay, go ahead, Brad.
Oh, sorry, my hand was, I forgot to put it down the last time. That's all. Sorry.
Okay. Thank you. Takas.
Thank you. Just a reminder that there are elements of contemporaneous or collaborative approaches in the presence of the auditor, monitor, or designee of the board in an investigation. This is all also linked to what exactly the board is, what kind of oversight the board is providing and the scope of the oversight. So if the scope of the oversight, for example, is our police department, following the rules? Are they not profiling somebody? Is there not a racial bias? Is there not? So these are issues. When the Commonwealth, as far as I understand that, when the Commonwealth Attorney, takes the issue, then they are investigating something different. They investigate the criminal charge, whether this needs to be prosecuted, whether people have an interest to prosecute this, etc. So these are two different levels, in my opinion. They intersect, overlap, no question about that, but they're different. And I do think that the police review board, especially when in the phase we are in the country and in the Commonwealth. Providing the access to the investigation in a contemporaneous manner is a very serious advantage with regards to the specific scope of why we want this oversight. Just an opinion for now.
Mm-hmm. So what I'm going to suggest, unless I see additional closing thoughts, is that we've tried to. It sounds as though the flow charts that you originally mentioned, Brad, would be really helpful, I know, for me. It also sounds as though it's worth taking some time with the document that we provided, the different scenarios and the areas for questions. And then I do think it will be very important that we continue to get engaged. The 22nd, we'll have a listening session, and we'll try to divide into some different buckets, areas for testimony and thoughts from our community as a whole. But then the key, that there will be additional, the time for revising the draft is still to come. There have been some thoughts, of course, at request to advertise in May, but the time for revising it and working on new language or working on other language that you would suggest, that is all to come. And so I think that that's what will lead us to a well thought through idea rather than the mess that we were talking about earlier. So I see Mr. Schwartz and Ms. Crystal, and Mr. Schwartz, go ahead quickly. I don't know. I think Ms. Crystal was first.
Right.
Go ahead.
My only comment was to remind everybody that we have been promised, we will see by June 30th, we have provided a set of internal affairs cases that are being reviewed by an external party. We'll get that review back, and then also a analysis of the statistical disparities in arrests in the county done by that same external party. So we hope that won't be ready by the 22nd of June, but that certainly should be ready by the end of the month.
That's very helpful as we're trying to sort of find out, think about what's at stake, what's engaged in Arlington, and what we need to do next steps. Ms. Crystal.
Well, one question I wanted to just put out there before we close entirely, what's ringing in my ears, there are a lot of really helpful takeaways, and I'm so appreciative of this time with our community members who've studied this most deeply. One of the things that's really ringing in my ears is, Brad, your point about actually the auditing function is the most important thing the CRB will do, because our problems, not to put words in your mouth, but our problems are policy related, more so than individual misconduct. And that really landed with me. It also made me question whether there are any other areas of the Civilian Review Board that we may be overlooking. I think we've dug in, I've dug in and tried to work with the manager to put together this chart on investigative authority, because that's what's controversial. And so that's what we heard a lot of feedback on. There were some differences of opinion among community stakeholders and our manager. And so I think we, as the board members, kind of chased that controversy. And this has been really enlightening, right, in terms of figuring that out. But I also want to make sure we're not missing another big piece of the picture about, whether it's things like membership, appointments, other functions within the scope of the CRB that are really important, either to the members of our PPG who studied civilian review and oversight boards most in depth, or to our other stakeholders in our criminal justice system, be that Latasha, Prissa, or Brad. So what didn't we ask, I suppose, is my question that you want to make sure we're thinking about.
Or are there so many things we didn't ask that you just can't think of them all at the same time? We have a no disciplinary authority is a question that was asked. And that's one where we'd have to think of the scope of the RTA. And then there's, I think in this is the second page is at the bottom under the Alexandria City proposed ordinance. There's whether a CRB makes recommendations, and the police chief then would have to say why she or he does or does not agree. But that's one area that we'll take, and maybe we can sort of ask that Brad, Parissa, Latasha, and Rodney, Kim, Saul, we can't say we'll double your pay because you're volunteers, but we can say we would love any of your insights off. If a better forum is to think about this and sleep on it overnight, but you don't, either through research if so motivated, or just through your thoughts. I know each of the members of the board would be, as well as all of us, would benefit from your insights. Mr. Dorsey, Christian.
Yeah, I just love one of the things. I love Ms. Crystal's last point, and I think among the things that keep me up at night about all of this is that we've talked about all of this theoretically. We haven't really put ourselves in the standpoint of thinking about it from the perspective of what members of our community are going to be on this body and the level of training, responsibility, background, materials, insights that they're going to need to be for our desires to have this be an element of our systemic public trust in policing. We're going to need them to put in a ridiculous amount of work. And so as we sort of think about just things like discipline and whatever, just remember they always come with the responsibility that the people who are going to take on this role are going to do the necessary work so that they represent our interests well. And so, you know, I haven't even really put my head around all of that's going to be required on the part of people who may take this on, and we may seek to do it.
I think that's an important point. And, you know, I kind of feel like now, Rodney, you're supposed to come in and say, we're happy to do all the work that's ever out there in any context. Go ahead, Rodney.
My question or my point was much simpler than that. What is my homework to come back with? I just want to make sure I've gotten my notes as to what I should come back to you with and how I can help us move this ball forward.
That's a great question, and specifically thought through, I guess, and I'll welcome help on this. There are two thoughts. One, if you could take the document that Ms. Crystal prepared and we shared with you and offer your thoughts on, you know, there are paragraphs in each piece. Offer a few, maybe your top 5 or 10 thoughts on the whole thing, with 2 or 3 maybe in each of the 3 fact patterns. That's one piece of thoughts, of homework that I'd request. And then a second is, it's sort of the broad question that Ms. Crystal asked. If as a group of 4 or individually, you as the subcommittee members, and we did invite the 5th member, Kent Carter, he couldn't make it. But if you have thoughts about the proposed text of the draft ordinance, we would also benefit from that, I think, because eventually we're going to have to take these concepts and put them into legislative language. And so those are the 2 buckets that would be, I think, would be helpful, and they're submitted respectfully. Don't, I know you have a whole separate day job that you've taken now 2 hours out of. So, but I think we would benefit from this, because in addition to this big discussion, we now want to use it to pre-prepare the right policy rather than after the fact have to correct too much. Does that work?
That's helpful. And with regard to the issue of sequencing, I had mentioned earlier that the answers out there of what others are doing, I just didn't find them. Did you want us to also, or is someone going to, besides what Brad has done, thank you very much, Brad, for what you've done so far, speak to other entities, NACOL or whomever, to determine, okay, what are the certain jurisdictions doing and how are they operating? Are they working it successfully, or what challenges are they seeing when they do it sequentially or concurrently?
That's a great question, and absolutely we would benefit from it. I also think that we probably ought to find a member of our team to help with that process, so it's not only you. And I don't know, Mr. Schwartz, I mean, if you have any suggestions as to whether that we have that capacity. We're doing about 4 major policy things at once this month. So
I see that Lynn Porphyry, who's on vacation, made the mistake of tuning in. So Rodney, I don't know if you have Lynn's phone number.
Lynn wishes I didn't have her phone number.
Yeah, so I was nearly going to say that and hoping you would say that, Mark, but that's where, you know, working together, and we may not get it perfect, but certainly NACOL we have to engage with further. So it is turned 5 o'clock. I see, I think that's a vestigial hand, Christian, is that right? Yeah, so just, I know on behalf of all of the members of the board, and thanks to each of you on the PPG for taking time, Parissa, Min Chow, and Brad, each of you, thanks for taking time. I do think there's a degree to which Ms. Crystal and Mr. Dorsey, you two, of Brad's comments were really resonant. So we'll want to pursue that. But it's 5 o'clock in probably everywhere each of us are sitting, and there's a song for that. And so I will suggest that we move forward, and all feel free to engage with us, but mostly thank you for the time and the discussion. And without objection, we will adjourn for the afternoon. Thank you, everyone, so much.
Thank you all. Have a wonderful evening.
Thanks.
Thank you, Ronnie, everybody.